All rise. The Court of Appeals Division 1 is now in session.
Thank you. Be seated. Good morning. We are here for our argument in CV 22-0137, Atlas Residential versus Phoenician Palms Condominium Association. As you probably know, we record and are now live streaming these arguments, so please give your name and the name of the client that you're here to represent when you begin speaking. You have a maximum of 20 minutes per side. You're not required to use all of that time, although it is available to you. We do require you to keep track of your time. The clocks are on the podium. If you'd like to save time for rebuttal, that is up to you. Keep in mind, we've read your briefing. We've read all supplemental filings. We've studied the record. We've discussed the case in conference this morning. And with that, please proceed.
Good morning. May it please the Court. My name is Doug Erickson. I represent the appellants in this matter. It makes sense to me to begin with the questions that the Court recently posed by way of an order on December 8th. The Court asked specifically that counsel be prepared to address three questions, and I would like to address those before I begin the substance of my argument. The first question is whether the record on appeal reflects the sale of the condominiums at issue for the arbitrated price is complete, or whether it does. The answer to that question is no, and the answer to that question is no for a couple of reasons. First of all, the sale is not complete. To the best of my knowledge, and as far as the record reflects, the plaintiffs have not been paid the amounts of money that were due if the arbitration amounts are to be paid. Secondly, the debt that covers the units at issue, which is required to be paid by the defendants, particularly LJ Phoenician Acquisitions, pursuant to the agreement that is within the termination agreement, has not been paid, and that's an amount of several $1 million. But even with those things as they may be, the sale is also not complete because the deed, which counsel was kind enough to supply to the Court, I think it's already in the record, but the deed, the warranty deed from the association to Phoenician Acquisitions is part of your record for certain. But for the reasons that I will describe and explain as I go through my oral argument, that deed itself is void and unenforceable. So our position is that the record does not reflect that the sale is complete. So the second question, must the record reflect the completed sale for the case to be moot? Well, the case is not moot, and it's not moot because although when plaintiffs originally sought injunctive relief from the trial court, the goal was in fact to prevent the sale of their units to anyone, under the arbitration process in the 2018 statute, which we now know does not actually apply, the sale that did occur and that's reflected in that deed is to a party to this litigation. It's to LJ Phoenician Acquisitions. So the real concern, the heart of the issue and concern for the plaintiffs originally was that there be a sale to a third party or a bona fide purchaser.
Do we look to the heart, the plaintiff's heart of concern, or do we look to the terms of the complaint requesting the injunction? Because my recollection was that the injunction request was not to enjoin the sale to anyone. It was specifically to enjoin the sale that occurred or maybe didn't occur here.
Well, that was the relief sought, and the thinking being that that was how the sale was structured, is that it would be transferred to the defendant's entity.
But isn't that how we evaluate mootness as to a particular injunction request?
Well, in this case, I don't think so because of the court's third question, which is, can the transaction be unwound? Is there still a reason for this court to consider the appeal that we've raised?
So not factually, but legally speaking, can you tell me what your support for that proposition is? That mootness can be, assuming for the sake of this question that we found mootness had occurred because the specific sale you sought to enjoin had already occurred. What is your legal authority that mootness can be defeated by the court just simply stepping in and unwinding the action that caused mootness?
Well, I don't think that mootness will be found because the court standard is the court will dismiss an appeal.
But I'm asking you to assume the mootness portion just so that we can get at that next part of the question, which is what I really want to find is what is the legal authority for unwinding a transaction as a resolution? Because what you're saying here is that because the whatever has occurred on the trajectory of the sale, we can just sort of like walk that back.
Well, if the court recognizes, as I will be arguing, and as we argue below, that the association had no authority, no legal authority to either enter that contract to sell the property or to execute that deed, then I think all that needs to happen is for that to be recognized.
But how is that at least the ultimate decision on that before us? Did you appeal from the order approving the arbitration result or confirming the arbitration result?
We did not. I think that's going to be a factor at the end of the day, the value of those units. It's not dispositive. In fact...
I assume there was part of that order was also that that the sale now can go forward?
No, sir. Actually, the defendants asked that be made part of the arbitration award. That issue, that authority was not before the arbitrator. We objected to the trial court, and I think this is in the record. And the trial court did not make that part of the order. All the trial court did was confirm these values for these units.
Okay. Then how did the sale go forward?
Well, the sale went forward because the association simply issued a warranty deed, paid an amount of money into an escrow company, and there it sits. I think they did their best to try to execute that sale under the circumstances, but in point of fact, they had no authority to execute that deed and no authority to do the sale.
Okay.
So as I understand the court standard, it dismisses an appeal as moot when the reviewing court's action will have no effect on the parties. And that's from the Cardoza case from 2012. And as I hope I've explained, this court's ruling will still have an effect on the parties, particularly if it recognizes, as I think the record clearly supports, that the association had no authority to conduct this sale. So we did not appeal the trial court's ruling with respect to the termination itself. And what the termination statute provides are two things. One, it allows 80% of the owners or more to vote to terminate a condominium. That much is pretty clear, and it doesn't matter whether we apply the 1986 statute or the 2018 statute. What the statute also recognizes is that the association may sell the property subsequent to termination. And the language of the statute is pretty important. What the statute provides in ARS 33-1228 in paragraph D is that the association, on behalf of the unit owners, may contract for the sale of real estate in the condominium. So that's a separate issue. That's not 80% of the owners taking an action. That is a legal entity, the homeowners association, having the ability to enter a sale. So we have the termination with 80% of the owners acting, and then separately we have a sale proposed. That's action taken by the association, which changes the rules of the game, and I think this is where the trial court got hung up. Because as we all know, a corporation exists only because the law says it does. The corporation can act only through its board of directors, officers, agents, etc. And those officers and directors must be operating within the scope of their authority and only in accordance with the corporation's rules of governance. Nothing in the termination statute that we're talking about, either version, the 1986, which we now know via this court's decision in July in Cow, is the one to apply here, or the 2018 version that the trial court and the parties at that point in time who believed that was the statute that applied. It doesn't matter which version of the statute we apply. There's nothing in that statute that allows the association to act other than through its board of directors. There is nothing in that statute that allows the board to act outside the bounds of its corporate powers. There's nothing in that statute that allows the directors or the association to violate the association's rules of governance, including the bylaws, which all the owners had agreed to. There's nothing that eliminates the association's legal or fiduciary duties to the owners.
And pardon me if I'm just not, well-versed in this area, but the termination occurs. So you've terminated the association. And so your read is that under the statute, nonetheless, the association's bylaws control what occurs after the association itself has been terminated and no longer exists?
Well, the association still exists until title is transferred, and the statute actually sort of spells out exactly how that develops. So the association has to exist in order to sign off on a sale and perform on a sale. So the association still is in existence. Now, they may take the position that it's not today because that deed was executed. But in terms of negotiating a sale, signing a sales agreement, and acting to perform on that sale, the association still existed. And there's nothing in the statute that changes or gives the association the ability to act without following the bylaws, act in violation of its fiduciary duties. And the other thing that wasn't appealed by either side is some of the trial court's findings with respect to how that vote came down. Now, the trial court decided that a vote approving the termination was not necessary. And it's our position under both statutes that's true, because it's the owners taking action to terminate. But to sell the property, that is the association and only the association that can act, and it must act in a specific way. At a minimum, we already know that there was one better offer out there than what actually transpired, which goes to the fiduciary duty aspect. But as the trial court determined, there was only a single director who negotiated this sale and approved the sale and performed the sale. Under the bylaws, which were binding on the association, three directors were required for the association to act at all.
How does the fact that, so among other people, I think one of your clients was invited to join the board. There were members of the board that absconded and fled. The sole member of the board attempted to populate that board and was unable to do so. How did those facts enter into this concern? Is it the position that they had as the majority owner, he had the authority to terminate the condominium association, but because of the actions of folks leaving the board or failing to populate the board, he could never do anything in terms of a sale because there were no other members of the board?
Well, just technically, he, Mr. Lee, could not terminate. 80% of,
yes,
which he controlled, 80% of the owners could, in fact, terminate. But yes, the association could not act without three directors.
What if it's a legal or factual impossibility? Can't the court step in there and approve it nonetheless?
Well, I don't think so.
It just goes on in perpetuity then?
Well, they would have to find a way to populate that that board. And just to correct your review of the record, there's an affidavit from Mr. Lariva, which is, I think, filed on September 21st. I don't have the index of record site right off the top of my head, but it was filed in conjunction with our original request for an injunction, where he lays out, yes, he volunteered to join the board, and Mr. Lee said no. The other members of the board, as I understand it, one was his wife, who is disqualified under the bylaws, and at some point there was a third. I don't recall who that was. But the point of the matter is, and what the Trico Electric case says, Judge, to your question, by the way, is that where there's an ultra vires act, that act cannot be validated by ratification or otherwise. And to answer your question, I'm not aware of any authority that would allow this court to supersede the law and say, okay, there wasn't a valid board, but this association could act anyway and act lawfully. I don't think there's any authority for that. And I guess I want to reserve a little bit of time for possible rebuttal, so let me just add this. I think it's very clear from the record, and I think the trial court just did not focus on the sale component of this. And I think that's the problem. That's why we've wound up here today. And I think it's clear from the bylaws, which are part of the record, and the authority that we've cited, which provides that ultra vires acts are void. The applicable statute says the same thing. And the statute that governs this board is ARS 33-1243. And that statute provides, if any contract, decision, or other action for compensation taken by or on behalf of the Board of Directors would benefit any member of the Board of Directors or any person who is a parent, grandparent, spouse, etc., that member of the board shall declare a conflict of interest for that issue. Any contract entered into in violation of this subsection is void and unenforceable. So not only does the common law state that the association can't act without a properly constituted board with disinterested members, honoring their fiduciary duties, but the statute which governs the operation of this entity, this association, expressly says that as well. And as the trial court found, Mr. Lee was clearly interested. He constructed this whole transaction so he could sell the complex to himself and turn around, and what we were really, at the end of the day, looking to avoid is what we knew was going to happen was he was going to turn around and sell the entire thing for a much, much greater amount of money. And that effort has, in fact, been made. So with that said, I've got about 3.5 minutes left. I'd like to reserve that for a possible rebuttal.
Thank you.
Presiding Judge Perkins, and may it please the court, I'm Charles Markle with Fenimore Craig. I represent the appellees in this matter, LJ Phoenician. I'll refer to them collectively as Phoenician, and I'll refer to appellant as Atlas. I'm joined by my co-counsel Mike Shern as well. Your Honors, this appeal was rendered moot on July 20th, 2022, when Atlas failed to appeal and even expressly consented to the entry of the $1.6 million arbitration award in its favor.
Counsel, why did we just become aware of this mootness suggestion or theory just very recently?
Your Honor, 2 points on that. At the time, I'm assuming the court means why was this not raised in the answering brief?
Exactly.
Thank you, Your Honor. The reason it was not raised in the answering brief is because the time to appeal had not run at the time that Phoenician's answering brief was due. So that issue was not ripe to bring to the court. It had not become moot yet.
But certainly you could have filed a motion or an advisement or a notice to this court to advise us that there are other events transpiring that would have perhaps mooted the appeal?
I think Your Honor is correct. And I would ask that the court excuse the failure to do that because I do not believe it has a legal effect on the mootness argument, but I do certainly take the court's point. We could have filed something earlier. That order did complete the sale. You heard a different argument a moment ago, which is incorrect. Atlas has asked the court to stop the sale from happening. But since that award is now a final unappealable order, the requested relief for overturning the lower court's refusal to stop the sale is essentially mooted and cannot
Could you
occur
respond
now.
to his points that he made regarding what the arbitration award actually said and what the court's order actually said as far as whether it approved or directed the sale to occur, or did it just say this is the price if the sale occurs?
I could respond to that, Judge Morse, of course, and I will. I would go the other way, not just factually and legally, but the process that was communicated to you is backwards. The statute actually says that on October 1st, 2021, when that termination agreement was recorded, as a matter of law, the condominium ceased to exist. There are no more condo units. It's done. And that termination agreement is not in dispute today and is not part of this appeal. That termination agreement expressly sets forth the terms of the sale. I've done more condominium terminations with my co-counsel than anyone else in the state of Arizona, and I will tell you, termination agreements are purchase contracts. When that termination agreement is entered, the condo dissolves, and the terms of the sale are set forth in that agreement, which is what the statute requires. Following the terms of that sale, on January 27, 2021, after the court denied injunctive relief and said the transaction can proceed, Phoenician recorded the conveying instrument, which is the warranty deed. The termination agreement first transferred title from Atlas to the association by operation of law, and again, the condo units went out of existence. And then on January 27th, that title, which was held in trust for Atlas, was transferred to Phoenician. What happens then is you have a contract, it's enforceable, and you have a conveyance of title. What you don't have, Judge Morse, yet is a price term. And the statute says how to go get that price term, and you go get it through binding arbitration, which is what Judge Thomason ordered the parties to do, and it is what the state legislature has provided is the sole remedy in a condominium termination situation as we have here today.
So, help me understand this. So, isn't there a monkey wrench potentially thrown into your timeline? And I appreciate you laying that out. But if the association had no legal authority to act, as opposing counsel has suggested, then where does that leave us? I mean, I'm sure you're going to enlighten me on that, how one member can appropriately act on behalf of the association.
Your Honor, I believe you know the answer to that because of the question that you asked previously. It would be unreasonable, and indeed it is an unreasonable position to state, as Judge Perkins as well, that you can simply refuse to join the board and therefore say, oh, well, there's not enough board members and so we can't act. There's a lack of authority to act. That is an unreasonable position to take.
Counsel's response to that was that I am factually mistaken in my understanding there, so can you respond to that?
Judge Perkins, I am concerned about that representation that was made on the record to this court today. I don't know how to deal with it other than to say that in the arbitration record, it is an undisputed fact that Atlas was invited to be a part of the board. So I don't know why that representation is being made to the court. I don't want to make a bigger deal about it than that, but it is certainly my understanding that it is an undisputed fact that Mr. Larava was invited to join the board and he refused. And so, again, what are we supposed to do in that situation? I would also take a step back. The lack of authority argument in its entirety is a red herring because the statute does not require the board to take a legal act. The statute defers to the 80% owners. And I would ask the court to think about what it does every day. I know it doesn't do condo terminations every day, but think about any corporation. 51% of the shareholders of any corporation can authorize the sale of the corporation or the sale of the corporation's assets. And the 49% have nothing to say about it other than to collect the proceeds of that sale. In this case, the statute, which is a uniform act, it's been adopted in something like 30 jurisdictions, says we're not going to do 51%, we're going to do 80%. And in this case, more than 80% was reached. That authority is given. All the association does under the statute is notice a meeting to present to the membership whether or not the 80% has been reached. Once that voting power has been reached, the association is in a situation where it does nothing other than approve that, yes, we've reviewed this, there you go, that you've got the 80%. And then now the termination agreement sets forth what happens next. And I actually think, look, the legislature doesn't always get it right, but 331228 is a fantastic compromise that essentially moves the hot potato of what is the board to do in this situation. It takes it completely out of their control. And it removes the fiduciary duty question as well, because it says, look, you've got 60 days to go get a competing appraisal. If you disagree with what our professional independent appraiser said, go get a competing appraisal, bring it back. If it's within, you know the statute, if it's within 5%, the higher price immediately is the sale price. If it's a greater than 5% difference, the parties submit to binding arbitration. Judge Thomason correctly said, you have an adequate remedy at law. Go figure out, Judge Morse, to your point, the price term. You have a contract, you have everything set to go. The last thing you need to do is to find a price term. And that, according to the state legislature, you get by going through the arbitration process. That's what the parties did here. I would like the court to know one more thing. Atlas blew the 60-day deadline. They didn't go get the competing appraisal. They did not comply with the statute. But at the September 20th, 2021 preliminary injunction hearing, my client's Phoenician stipulated on the record to Judge Thomason, you're right. We have an adequate remedy. It's arbitration. And we will let Atlas go get a competing appraisal, and we will not take the position that they've blown the deadline. We will, in good faith, arbitrate with these parties. And, Your Honors, that's what happened in this case. They then spent several months arbitrating the value. And then Schoen-Fogel delivered his award on May 25th. And that award was then confirmed on June 30th by Judge Thomason. And again, in that briefing, Atlas itself stipulated to the appropriateness of the award. So there is no dispute that the fair market value of these units is $1.6 million. And again, to the fiduciary duty argument, it's a complete red herring. And I'd like to do the math for the court, which I am an attorney, so I need to read math. The point being here is that there isn't a fiduciary duty anywhere at law. There is no concept of a fiduciary duty that would require any fiduciary to obtain a greater than fair market value price for the sale of any asset. So with that proposition, even still, no one in this case offered more than $1.6 million. And that's the amount that the arbitrator ordered Phoenician to pay. Atlas' argument is that since there was a previous offer for 5% more than defendant's opening appraisal amount, that constitutes a breach of fiduciary duty, and that contract should have been entered into. But Atlas received significantly above the offer after arbitration. So here's the math. The arbitration award confirms, and this is it, answering brief, Appendix 1, Exhibit A is the arbitration award. The opening appraisal is $1.34 million. Plus the 5% that the statute requires for relocation costs, you get just above $1.4 million. There is no dispute that the arbitration award of $1.6 million is $200,000 more than Atlas said it should have received in this case. The breach of fiduciary duty question is completely pulled off the table because Atlas received more than it claims what it's owed in this matter. And again, there's no duty for any fiduciary to achieve something greater than fair market value. So I want to circle back to mootness, and I want to circle back to the court's question about unwinding the transaction, unless there's something pending that I've not addressed. No, okay, I thought I saw something. The specific question as to whether or not the sale can be unwound. I understand the tenor of that question, and I appreciate it. The facts of this case, however, prevent unwinding the transaction, and I think for two critical reasons. The first, again, is that unappealable final arbitration award. Atlas consented to that number expressly. We have a fair market value determination. We have the price term, Judge Morse. That is the conclusion of the transaction. Title conveyed. The warranty deed, title conveyed from Atlas to the association on October 1st under the termination agreement. Title conveyed from Phoenician to the other party, Phoenician, on January 27th through the warranty deed. And the price term was thereafter litigated, which is what always happens in these transactions. You have the conveyance and then you litigate the price. I know that's unorthodox, but that's what happens. And so that's the first reason that you should not unwind this transaction. Because there would be no purpose in unwinding it. Are we literally going to do the arbitration again and find a different value, even though Atlas has waived their right to appeal that valuation and expressly consented to it? I don't think that's the right approach. Second, Atlas does not contest the termination itself. The more I review this record and the more I study the statute, I believe this is the most important admission that is made from Atlas in this case. If you unwind the transaction, all you would be doing is unwinding it just to wind it back up again. And that is for the reasons I set forth before. The termination, which occurred on October 1st, 2021, via recordation of the termination agreement, as the statute provides, that is the purchase contract. So if we go back to this date and time that they do not dispute happened, they do not dispute the termination, we go back and then we just go forward because the termination agreement expressly sets forth the arbitration provision and how this process is going to play out between the parties. So you would literally unwind it to wind it back up again, which doesn't make sense. And
Shouldn't the trial court, well, just ask, shouldn't the trial court have issued the stay or the preliminary injunction pending the results of the arbitration?
I will represent you, Judge Morris. I've never had a trial court do that, and here's why. The statute, I went on motions.
I don't know how, I appreciate you telling us about your experience, but I don't consider it to be a binding precedent, so please proceed.
Very fair, Your Honor. I would agree with that. The reason the court shouldn't do that is because it fails the preliminary injunction test. It fails the irreparable harm standard, if nothing else. And Judge Thomason was correct to find that. The reason it does is because the state legislature has expressly said these claims don't come to Superior Court. These claims are handled in private arbitration. So go do your private arbitration. If there is a problem with your private arbitration, parties have the right to appeal that. That did not happen here. So Judge Thomason was absolutely right.
But he shouldn't have stayed it pending the arbitration?
So here's, I don't believe he should have done that. I believe he did the right thing in this case. But I will also argue, if you disagree, and if you believe, if this court believes that the injunction should have issued, I would submit to you then, after the arbitration order came on May 25th, the parties would simply have gone to the court and said, now we have the price term, would you please lift the injunction so we can complete the sale? And because this court denied 2 stays of the lower court action, and because the lower court denied 3 requests for injunctive relief to stop the sale, the process continued, and the parties litigated in good faith.
Because I'm hung up on, and this is probably a whole bunch of dicta right now that I'm thinking about from the bench, but it seems to me either one of you should have been entitled to an injunction in one form or another. You could either enjoin them or seek preliminary injunction, because you have a sale contract via the way the statute works, or at least that's your argument to us. Could have forced them, enjoined them, forced them to proceed in the arbitration, because it's a sale for the contract or a contract for the sale of land, which can be specific, you can require specific performance for it. They could say, if you were refusing to proceed to arbitration, they can't do anything to our property until this arbitration fills in the final number, so enjoin them from doing anything else. That's why I'm kind of, it seems like the irreparable harm doesn't work for me, because the irreparable harm is forcing the sale without all the proper terms being filled in.
I understand the position and the tenor of the question, certainly. The irreparable harm argument fails because we're fighting over money. At the outset, Atlas wanted more money. They wanted 5% more. They ended up getting $200,000 more under the fair market.
What percent is that?
What percent is $200,000? You're asking me to do math on the record, live stream. So the opening amount would be 1.4. 200,000 more would be 15%?
Somewhere around there.
Yeah,
Okay.
thank you. Not an immaterial figure, and one that was litigated in good faith between the parties. There was another representation made to the court that Atlas hasn't been paid. I don't want to camp on this, and I don't want to make a bigger deal than needs to be made. That is not a true statement. There was an admission that the money was escrowed. That money was then tendered. Atlas refused to take it. That money has now actually been pulled out of escrow to protect Atlas from the escheatment laws running and all of that money going to the state. So it is Atlas's refusal to cooperate and accept payment that has delayed this process. Moreover, the issue regarding creditors and debts is just factually incorrect. As you know, in any real estate transaction, there's payoff requests to creditors. Those payoff requests have all been accepted, worked into the closing statement, and Atlas refuses to agree to apply the monies to release the debts. So it is not true that payment has not been tendered, and it is absolutely true that this transaction is completed. And so what this court has been presented with is a request to stop a sale that has already occurred. And again, to your point, Judge Morris, even if the court believes the injunction should have issued, at this date, the parties would simply have gone back to Thomason and said, Your Honor, will you please lift the injunction so that we can complete the sale. And this is hypothetical, and there was no injunction, but I don't understand why there would be any refusal to lift that. There can't be a breach of fiduciary duty because of the fair market value determination being made. A fiduciary is not required to get more than fair market value for any asset. The lack of authority arguments are dismissed under a plain reading of the statute. The association is not required to take any act. Judge Thomason correctly found that issue.
Just back on the mootness, based on the questions that we asked, we're in kind of an interesting spot here because we have some diametrically opposed statements being made here today, and I don't know how much of this we have a reliable record to look to. So can you help me on that, those sort of first two questions on the order that we issued?
And the issue would be on, the two issues that I'm contesting, you're saying, would be on whether offers were made to join the board and refused, and then whether payment has been tendered?
I'm not sure about that first issue being relevant to mootness, but just in terms of, we just a couple of weeks ago here that this case may be moot, and we're looking to the record to determine whether or not we can, find support for that position. What is in the record when we have the parties in some dispute over whether the sale has actually occurred?
I do not have any correspondence or any title report or correspondence with title regarding the escrow. What I can say, and what the court can do as a matter of law, is use the rule where when an argument is presented and is not responded to, it is waived. And you can look at the answering brief where we expressly state on the record that payment has been tendered. They've been paid. We have the $1.6 million, and it has been paid. It has been tendered to the other side. There is no dispute in the reply brief. No one blew the whistle and said, "What are you talking about? We were never paid." Moreover, the court can look at the record that says that they expressly consented to the $1.6 million valuation. So I do not believe that is reasonably in dispute. And I think by not responding to it in the reply brief, the court should credit the statement that was made in the answering brief. However, if the court would like supplemental briefing before the end of the week, I would be happy to supply evidence to the record if the court would allow that supplement.
I think Judge Perkins' question and the question that we directed the parties is, to what extent can we allow you to supplement? I mean, aren't we limited to what the record on appeal is at the time the appeal was filed?
Yes, you're limited to the record, but you also have the authority to supplement that record when justice would so require. And if you believe that the mootness argument is correct, but you want to finish that connect that final dot, then we will provide the escrow correspondence to do it. Again, that was not reasonably in dispute at the time of this briefing, and so that's why it was not put on the record. And again, there is no response in the reply brief that there is any dispute as to payment. So I was surprised to hear that representation on the record made to you today. My final thoughts would simply be the appeal is moot and should be denied. If the court disagrees on the merits, there's no irreparable harm here. For the same reasons, we're arguing that the appeal is moot. Judge Thompson was correct when he denied injunctive relief, and he directed the parties to pursue the express remedy that the state legislature has provided them, arbitration. They did that. Atlas made $1.6 million, and that was more than $200,000 that it requested it was owed, and which is the entire basis of the fiduciary duty argument.
Thank you, counsel. Your time has expired.
Well, briefly, just so that the court has the benefit of the record, since I guess it's been suggested I've misrepresented it. With respect to Mr. LaRiva's refusing to become a member of the board, I would direct the court simply to index of record item number 35, paragraph 24, where Mr. LaRiva gave a statement under oath that he was willing to serve on the board, but Mr. Lee and I disagreed as to whether he had been rejected or not. So even while this was all transpiring, Mr. LaRiva was offering. I don't know that it makes any difference, but I think the board is required to follow its bylaws. It's required to have those 3 disinterested members in order to act, and that's sort of the end of the story. Now,
I don't want to tip my hand because I'm not sure what my hand holds right now, but I found the argument that your colleague made pretty compelling, that
yes, there's lots of things that require action by the board, but the statute doesn't require any action by the board once the termination occurs. Termination occurs and we just fall into the statutory process. Do you disagree with that?
I do, and the quotation that I read during my initial remarks, I think, addresses that, because it says that the association acts on behalf of the owners in contracting for the sale. The association, the statute does not bestow any special authority on the association to act, and that's a safeguard for the owners. And the other thing that I heard a moment ago is
But
that...
doesn't the statute provide, once the requisite number, the 80+% vote to terminate, this is how the units are then disposed of?
So I think that's a very important point, and I think it's important to recognize exactly what does happen under the statute. And for purposes of my comments, I'm going to focus on the 1986 statute because the 2018 statute is largely the same. One of two things happens upon a termination. So under paragraph D, if real estate is to be sold, title to the real estate vests in the association as a trustee. Now, on its face, that appears to be the scenario we are operating under, but in reality, it wasn't, because what the statute provides, it doesn't provide as represented that the sale can be negotiated in advance. What it says in paragraph C is the termination agreement, if there's to be a sale, shall set forth the minimum terms of the sale. So the owners understand what the minimum they could get is. That doesn't relieve the association of the duty to go out there as trustee and negotiate the best deal possible. So one of two things happens, though. If there is to be a sale, title transfers to the association upon termination. It holds it as trustee, and then as long as it holds title, the unit owners have, exclusive right to occupancy and use. If there is not to be a sale, and it's our position that there was no sale because this contract was ultra vires and it could not happen. If there was to be no sale, and this is where I think we stand today under paragraph E, then the title to real estate vests in the unit owners on termination as tenants in common. And I think in reality, that's how things stand today. The plaintiffs are owners as tenants in common, and they should have never
Thank you,
been
counsel. I appreciate
dispossessed.
your arguments. We'll take the matter under advisement, issue our decision in due course. We're going to stand in recess to reset.